Okay, there's an excellent set of
Maybe with the microphone a little closer, I think.
Okay. We have an excellent set of fine papers to begin with. Enrique Santamaria will start things off with some utopianism, and it's edged with what I like, revolutionary collectivism. The paper is advancing the right to health, private law models for the construction of the commons on health data, on biological human biological materials, and scientific knowledge.
Okay, great. Thank you very much. I would like to say first to all the organizers for this wonderful event, also to Laura for all the practical matters. And it corresponds to me to start the event with my presentation, for which I'm very nervous. I'm also very fortunate because all your minds are clear and you will listen to me, which is good. So indeed, my paper is called The Human Body Commons, How to Advance the Right to Health Through Private Law Instruments. And the idea behind this paper is to contribute to a solution of what I think is a problem nowadays in scientific research, and in particular in biomedical research, which is the enclosure of science and its resources. In particularly, I'll focus on three resources: human biological materials, data, and scientific knowledge. All these three are comprised in the paper under the term human body commons. I understand the idea of the human body commons might be misleading, but I refer to this type of sources and resources. Why do I refer to them and include human biological materials? Because this materiality is often ignored in discourses about the commons. And then where does private law come in? It comes in two different moments. First, on the discourses on the commons in general, on the different types of commons, and also in my paper on the analysis of different models to build commons, private law models. So okay, let's start with the first part, the different discourses on the commons. You're maybe, or for sure, well aware of the seminal article about the tragedy of the commons and how the commons cause resources to be depleted because self-interest drive individuals, and then there's no possibility to actually have commons. Since then, very different strands of literature have emerged, but I identify two. There might be more. One relating a bit with the theories about the public domain, which I will call the open commons, and the other one, which is based on the theories of Elinor Ostrom and the governance of common pool resources. But there are differences between them, and it's necessary to untangle the different theories about the commons, because when you think about the commons, you don't really know what people are talking about. And what I'm trying to do, I'm not the first, of course, is to disentangle these terminologies. So let's start with the open commons. The open commons it's a way of managing resources in which there is a symmetric freedom to operate. So everybody has the right to participate in the commons, but nobody from an undefined community has a right to exclude others. In this sense, open commons are a property outside, and here private law becomes interesting. It's outside the property realm. By contrast, common pool resources are a commons inside, but a property outside, in the sense that commons inside, because the members of a well-defined community have certain rules and access to a certain resource, but they can exclude others, and they can rely on property and the power of the state to exclude others to participating in the governance of common pool resources. Very well. Now, with this distinction, I would like to continue with one of the characteristics of the open commons. There are four, essentially, and on this I'm building on Benkler. The efficient allocation of the resources, it's quite easily done once it has been provisioned. There are positive externalities arising from the use of the resource. It can be used as an input to other goods, and the resource can be, let's say, provided in different settings: market settings, public settings, or nature settings. As you can imagine, if you think about these four characteristics, you can already imagine data, for example. It has positive externalities, can be used as input for other resources, can be provisioned in different scenarios. and the allocation of data is not a problem when it has been provisioned. Perfect. In these two strands of literature, however different they are, there are two problems that they share. One, they try to tackle the problem of how to share and how to circulate resources. And secondly, they want to tackle the problem of free riding, reseeding the commons, so how to feed again the commons so it can keep growing, and the problem of distributing its benefits. In the resources I'm trying to study, these problems are particularly difficult. As you know, data and knowledge are, at least in principle, non-rival resources, whereas human biological materials, human tissue, for example, are rival, excludable, and perishable, can be consumed after they have been used. So that's the first problem that arises. Can we actually put into play all these different types of resources under one idea of the commons? And the second problem is that these resources are circularly connected. So they can be used as an input for the other one. An example, data can be used as input for scientific knowledge. Scientific knowledge, in its turn, can be used to analyze human biological materials and so on and so forth. With the basic consequence that if you enclose one, that has negative impacts on the others. And if you open one, it has a positive impact on the others. So it's necessary to put these three types of resources into play and to see how we can govern them at the same time. I am, of course, and not by far, the first person to explore ideas of the commons and the data. That's well known, building on the theories of Armstrong, theories about, for example, genetic data, genetic commons, knowledge commons, genomic commons, medical information commons have been proposed, but among which, for example, by Professor Evans. This type of commons, in general, follow the structure of a common pool resource commons. So there are let's say, closed communities with a property outside and a commons inside. I will not focus right now into analyzing this type of theories, although it is described in the paper. But from these theories, I distill at least three conclusions. It is necessary to rethink privacy to account for relational theories of data, so how data from myself tells things about the others and can benefit but also harm others and groups and populations. It's necessary to take into account the embodiment of data, so biological materials, and we need clear rules to receive the commons. This is the first part, the theoretical part. Now let's go to the practical one. In the practical part, I studied different models that have been in practice to establish commons or quasi-commons on this type of resources. I go through the MTAs, material transfer agreements. I go to the history of them. I will not focus on that right now. I analyze a very nice structure called the Open Science Trust Agreement, which is a trust mechanism in which the trustee agrees not to seek to implement IP rights on the material that has been shared and agrees to put the resources and the publications and the results in the public domain, and also allows for the possibility of circulating the material to further trustees that agree to the same conditions, the same initial conditions. I have also studied data cooperatives. This is quite interesting. It's of course not new, but in Switzerland you have already very nice practical cases of data cooperatives. My Data is one of them. It's a non-profit data cooperative in which the Articles of Association give individuals the rights to decide what's going to be done with the pooled data mediated through a platform. This, of course, it's also private law. And I finalize with a critique, very short critique of a proposal in Europe about the European health data space. The proposal uses a language closely linked to the commons, and one might actually say that the proposal is claiming for an open commons on data, on health data at the European level, but that's a mistake, and I explain the reasons why. I will not go into deep into that because I have 2 minutes left and I would like to have a bit of time for questions. But to conclude, I will have to reach a few preliminary conclusions. The first one is different types of resources require different types of commons. So there are different types of commons you can build on human biological materials, on data, can be common pool resources, can be open commons. For example, for open commons, you can rely on public ordering, and for common pool resources, you can rely on private ordering. It is necessary also to rethink the requirement of consent for the use of data, for certain uses of data, and for that, further research is needed. We have to know, for example, what the common good is, what the general interest is, what the public interest is. It's a lot of vague terminology used nowadays to justify use of data without consent. And finally, it's hard to imagine open commons on human biological materials, whereas for other types of resources, that's very much possible. With this, I conclude, and I very much welcome your critique and comments. Thank you very much.
Impressively, we have 11 minutes for Q&A, and David, you can direct, as people raise their hands and they want to ask a question.
Yeah,
Sure. Do we have any questions? Mark Hall.
So, cover a lot of terrain here in terms of potential applications and potential concepts, and as I understand it, sort of map out broad categories of applications that might fall more comfortably within certain contexts. But I guess I'm, at the moment, at first encounter, wondering if you could give maybe perhaps a bit more of a concrete example with regard to ownership, control, development of either health information or things related to biological materials that would just help the first-time reader understand where that mapping would help point us in a better direction.
Right.
You mentioned a number of examples and models, but maybe pick one that you think makes good use of these concepts or could benefit from the concepts.
Okay. I think the idea of data cooperatives is quite interesting and can kind of like give a clear explanation of how this could work. So data cooperatives are, as the word says, a cooperative, in which participants can pull different types of sources of data, for example, from electronic health records, from wellness applications, the smartphones, from different kind of sources, and they can be put into one platform. And then they together, through different mechanisms, that depends on the type of cooperative, they can decide what are the purposes for which the data will be used. For example, will a pharmaceutical be allowed to use data for profit, non-for-profit, for types of specific types of research or not? If individuals don't want to participate, they can withdraw from participating. So keeping control on their data, but at the same time enabling a more of a collective type of management of our research, which also allows for a certain rebalancing of power when it comes to negotiating with companies or hospitals or other institutions. So the idea of the paper at the end, I think, is this is just one type, but you can try to create, and this needs further research, at least from my side, you can create a network of commons. So how to put into play different types of commons? I would say for biological materials, a biobank could be an example of how rules can be changed to create commons on biological materials, not open commons, because I don't think you could allow a open access to biological materials, but that could be an example, I hope.
So I'm hearing that sort of, I think the core insight I'm getting is you can create a type of commons through private ordering. That's, yeah, sort of like a clearinghouse for licenses. So you have a clearinghouse for access to data or biological materials. Okay.
It wouldn't work necessarily as a clearinghouse, although that has been already proposed, for example, in Belgium from Van Overvalen, clearinghouses as a mechanism to create open commons. So I'm not saying that there should be a specific type of commons to manage all these resources. What I'm trying to do is to see, given the different characteristics of the resources, how they can put into play different types of governance models to open as much as possible, but to also establish clear rules on what's going to happen with the benefits of research, which is also like my main concern. Who is going to exploit the research and for which purposes? And how is that going to go back to the people?
I think I saw a question from Chris Robertson first. Go ahead.
Thank you for your talk and the paper. I found the descriptive piece just introducing me to this landscape of agreements very useful. And I was surprised to learn about the NIH structure, the UMBTA, and its prohibition on commercial use of the data. And I wondered if you could comment a bit on I think your paper kind of suggested that was a barrier or a problem to its widespread use. You just commented, how do we get the benefits back to the people? Should we be thinking of the benefits primarily in terms of the profits and revenues, or should we think of the benefits primarily in terms of the health that you only generate if these things are commercialized and scaled up? As much of the rest of the NIH recognizes the Bayh-Dole Act that these inventions do no good if they just sit in an academic lab.
Yeah, thank you for your question. I think in the case of the UBMTA, the idea of prohibiting commercial companies from being a party to it was precisely that one, because different kind of commercial parties and non-profit parties have different kind of interests at hand. And these kind of contracts regulate also quite precisely IP rights. So they wanted to exclude commercial companies or commercial entities to participate in this kind of material, in this type of contracts, to avoid these kind of problems, the problems related to complicated IP rights discussions. It has, of course, been opened with these new models, but I completely agree with you. When I talk about reseeding the commons or giving back to the commons, it can take many ways. One way could be profits, of course, but another way could be sharing the knowledge that has been acquired by doing research on the resource, or by facilitating access to a certain drug or to a certain device or to a certain test. So that also would depend on the type of research that's being carried on, by whom, and for which purposes. Recently there has been a study at the European level about the willingness of individuals to kind of like donate their data, data altruism. And the study suggests that people are more willing to donate the data if the entities that are going to use it are non-profit and are not going to do it for profit purposes. It seems that the other way around, trust is eroded. So trust could be gained back if we put clear rules on what's going to happen with the data. That's what I think, preliminarily.
Great, so we're going to pair the next two questions together, and we'll see if you have time for an answer. But Craig had a question, then Jimena, but Craig, go ahead first.
Very briefly, I'd be interested in hearing about if you have thoughts on how this might relate to secondary research, because in some ways I didn't know much about the remote trials, but secondary research sort of seems to be a way in which I thought about this is a way of doing remote trials, right, on work that's done afterwards, and there is an effort to try and think about how data networks across the United States form and how data should be shared with after 21st century cures, right, and the structure based on that. So I'd be kind of curious about if you might be extending your conceptual approach regarding the comments to that.
Great, let's get the second question. Go ahead, Jimena.
Thank you. Well, I will share later with you some specific comments on your paper, but one big reaction that I have related to the standardized MTAs, these standardized agreements. I mean, you're in several sections of your paper, you mentioned that you're looking forward to rebalancing powers, right? And I was a little bit skeptical when we were analyzing these agreements. Just because of the idea of standardizing, it's embedded a lot of power in there, and then the presence of misbalanced powers among these stakeholders, and these agreements are proposed by entities with their own conflicts of interest, which make me consider relevant to point out also the political challenges along these agreements. The examples that you bring to the paper are most from the developed world, and when we think about sharing knowledge and thinking in the pandemic, basically we're thinking in other kind of stakeholders, probably those stakeholders that will not have enough bargaining power to be in the table to get into these standardized agreements. So I was wondering exactly what do you mean by balancing powers, from whom and for what?
Great. I might come back to your first question. What do you mean exactly by secondary research? Okay, yeah. Okay, I'll start by the last question and come back to you. So in the models I study, I just study them to see how they are organizing the contracts and how they are opening access to certain resources. I do not necessarily endorse them. So I'm not necessarily defending any of the standardized contracts that I presented in the chapter as models for opening access to materials. Some of these models have been drawn by industry, that's actually true, but some others not. So it depends on the type of research. I know, for example, the first one, the UBMTA, has been used by a lot of nonprofits to share, for example, plasmids, and to make plasmids available for the research community at large without too much bargaining power. So it depends on the type of entities that are using it and for which purposes. But I'm for sure critical about some of them, particularly the last one that I analyzed, the Open Biological Material Transfer Agreement. I think that's complicated because it grants access to certain entities that perhaps should be moderated. Now, to go back to your first question, so electronic health records, I think, are part of the construction of a possible data commons, in the sense that data from patients will be accessible from many different parties, but also patients or non-patients as well can control it and give access to other types of parties. Now, the question for me is more not about the type of where the data is gathered, but what are the purposes for which the data is used. And I would say the commons are important for research that benefits the public at large. And on this, relational theories of governance of data are quite useful. Data solidarity has been used as one of the principles to govern data. So I think it's more how you govern it than where it's located. And with this, I think my time is off.
That'll have to be the last word. Big round of applause.
We're ready. Now for some hardcore legal realism from Lauren Roth, abandoning fiduciaries in favor of naked self-interest in healthcare.
Did you get this clicker?
Oh.
Pass it over.
So the slides are actually more of a threat than a tool that I plan to use. So the slides just have the charts related to the game theory component of my paper, in case there are any questions and people want to see it up there, but I suspect people would rather forget that part of the paper. So we'll, my goal is to spend about 5 minutes talking and then get more feedback, because I was like feeling nervous as the clock counted down because there were so many incredible questions. First, to go across panels for a second, which I'm sure violates some sort of conference norm. I love that today we'll talk about a paper arguing that we should expand fiduciary duties to private equity firms running nursing homes. In the same time that we're talking about my paper arguing that we should abandon fiduciary law in health entirely. And I think, so first of all, I think that makes the discussion fuller and more interesting, because we can talk about the impulses that could lead us in either direction. But I think it also gets at the idea, this hope and feeling that the legal scholars have had for many years that fiduciary law is not necessarily a panacea, but truly helps to govern relationships where there is a power imbalance and information asymmetries, that it can pull a lot of the weight. And sadly, in my hardcore realism paper, what I'm really getting at and what I've been, thinking about and turning over for a bunch of years now is the idea that I don't think it gets us very far at all. And in fact, I think it costs us a lot in terms of foregone opportunities for very specific and targeted legislation and regulation that could instead be safeguarding vulnerable parties. Much of the critique of ERISA's fiduciary duties as applied to health, and there's a lot out there, relates to the lack of enforcement or the limitation of remedies. And part of the reason I wanted to incorporate game theory into this paper was that, both that I wanted to show that it's unrealistic if you put yourself in that individual moment where providers or payers have to make a decision and take an action in our healthcare system. Even if you beefed up enforcement, even if you increased remedies, it doesn't get us far enough that it will significantly influence decisions at the individual level. And that's because the amount of enforcement, right, the penalty for getting caught and the likelihood that you would get caught has to be so great that we never get there. We never get to the point where it exceeds the self-interest, the rewards you can get for behaving in your own self-interest, even though I think there's this great hope that, putting the fiduciary label on people in health leads them to act in very noble ways, in ways that are different than how they would act if they were not labeled as fiduciaries. I think, it's unfortunate that almost from the very start after, ERISA, which again was intended to govern pensions, but really has become much more in the last several decades about how it governs healthcare in this country. I think there was this idea that in a system where, again, we're relying on employers to voluntarily provide benefits, that we could do that. We could encourage people to provide benefits and obviously leave them with all of this control and power over individual citizens because we had that safeguard of calling people fiduciaries and making sure that they were following their duty of care and duty of loyalty. So my argument is really not just that it's a failure in terms of ERISA, which I think it is, but also that if you play the game out, and hopefully I'll get the chance to kind of explore that a little further in the future, but if you play the game out, even looking at additional regulation and enforcement under the heading of fiduciary law, it doesn't get us to where we need to be, so it's time to look for something different. I'm already at my 5 minutes, look at that. So the last thing I'll say is that one area, so there are many areas where I'm sure you'll provide helpful feedback, but one area where I know I need significant feedback is that I know people are gonna get me on that last section going to value-based healthcare. I can just see it on your faces. Especially, given all of the literature, on what a failure in some ways that effort has been. Why bring it in here? And I could be convinced that it's not helpful. My question is there a way to salvage it in some way to at least minimize self-interested behavior by providers, or in this corporate sense of fiduciary law, to more closely align the interests of fiduciaries with patients, to provide the right incentives, right? Because the idea of game theory is that, people behave rationally, and is there a way to make it so that providers' interests are more closely aligned with patients, because then they will rationally do what's in the best interest of patients. So I'm gonna stop there before I say anything else.
Excellent. We have time for questions. Go ahead.
So I was struck by the breadth of your argument here, and I think I couldn't agree more that fiduciary duties have fallen short in all kinds of ways, but I wonder how we deal with the problem that there's always uncertainty and always difficult judgments to make. I mean, even in the most perfect value-based payment system, which I'm with you, it can work in certain settings, and I think there's room for improvement and room for many, many tools. But doesn't assigning it a fiduciary duty, even an unenforced one, give a provider a mental tool to make one judgment rather than another when they're faced with this kind of uncertainty?
So I think that's always been the hope,
right? This idea that, if you feel constrained even in some way, then it's doing some part of the work, and then we can go and fill in the gaps. But the evidence just shows that that hasn't been the case. And I think largely, that hasn't been the case in part because the less enforcement there is, the less risk there is, research is showing that it becomes acceptable behavior. So morally, you don't have to justify deviating from your fiduciary duties, because if every other provider, overbills, right, is churning through patients, not spending enough time with patients, then that is the standard, right? So because we use fiduciary labels and fiduciary duties to try to impress upon people what is appropriate and what's the correct behavior given the vulnerabilities of the patients, the beneficiaries, depending on the situation in fiduciary law. But when all of our other signals in health tell providers and tell payers that this is what acceptable conduct is, you can't go back and say, oh, but the statute says, because to them, this is what how a fiduciary behaves in health. So at this point, profit maximization, right, corporate consolidation, they know what's accepted and what's acceptable. And everyone has the fiduciary label, right? We've sort of used it as this broad tool across healthcare. So if you see other fiduciaries acting in these ways, I think it doesn't carry that weight anymore.
Yeah, quick follow-up, go ahead.
So are you taking away a tool for frontline providers if you do this? So I think it'd be helpful in the paper to be really clear about who you're talking about. So on the one hand, what you're saying rings very true to me about insurers, but frontline providers, the fiduciary duty and the medical ethics duty seem to be quite in parallel. So are you saying that it's not, the fiduciary duty is no longer relevant, no longer needed when we get down to that level? What do the providers have to fight back against the insurers?
To fight back against the insurers in terms of, depends how we're looking at this, right? So if we're looking at it as a pie where they're each trying to get that share, that's very different than looking at providers as true fiduciaries who are focused, they're the ones who are focused on the best interests of patients. And so most of what they do is to push back against, insurance companies who are trying to limit care to their patients, but that's not what the evidence shows. What the evidence shows is, especially due to corporate consolidation, they frequently don't have the best interests of patients. They justify, right? You can justify, ordering more tests and say, well, there's no incremental harm, to patients. But the reason they're doing it is not because they're focused on acting in a fiduciary way. Frequently, it's about because, corporate parent is pushing certain goals and needs that don't align with the best interests of patients. So, I think that maybe I'm coming from a much more cynical, hardcore place of thinking that, it is as much a concern how providers are behaving. And maybe that's also because the fiduciary duties aren't working.
So everybody's excited to this paper, but first we'll do Barry and then Christine, then we'll work our way around. Go ahead, Barry.
I think your focus on physicians and fiduciary duties is a good one. And I think you capture the limits of fiduciary law when it comes to physicians. I think there isn't too much evidence that they pay attention, and the corporatization of healthcare suggests you're probably right. All the signals are in the wrong direction. Now, the problem is you need another 5,000 word chapter in order to capture the economic model you develop. You suggest that economic incentives can be developed. We start with HMOs, which were a disaster in their attempt to incentivize physicians by salary holdbacks and so on. Now you move to value-based care, which if you look at CMS and hospital value-based care, sort of you play to the rules and you ignore other things because you want to capture revenue. And that's going to be the same with ACOs and so on. So you get into a tangled mess of incentives. And I'm not sure So I'm not sure your solution offers me much encouragement, although your answer on fiduciaries for physicians is probably right. So another article, another chapter, what?
Yeah, so that's interesting. So, I mean, so you're suggesting basically cleaving that part off, and really focusing on the earlier point about fiduciary incentives.
I'm not saying that. I think the economic signals are something we keep toying with. And they so often have cross currents and counterproductive effects because physicians, sometimes they ignore them and sometimes they pay too much attention to this targeted signal. So it's just something to think about as a comment in 5,000 words, which you've already exhausted.
Thank you. That's helpful. Thank you.
Christine, go ahead.
Thanks. I think this is a very valuable and very relevant piece right now. I'm engaging, and there's a lot of conversations happening in Congress today about kind of whether and how we should have entities like PBMs and TPAs be fiduciaries, or whether we should be having more specific rules to regulate their conduct. Ultimately, like, I'm kind of leaning towards, area where you maybe have some of both, in part because I think one of the difficulties with specific rules here is the complexity of these contracts and the ease with which the companies that are being regulated can change paths to then avoid them. And so I think one potential benefit of the kind of fiduciary approach is kind of setting more kind of this big picture expectation. And what else to say on, but I think like your contributions here are really valuable and would be welcome in Congress. And then to just on the payer side, my one concern here is that kind of the concept of payer being oversimplified, where it's really 2 or I think like 3+ entities involved, and they have very conflicting interests, and not all of them are necessarily fiduciaries, or would argue that they are not. And so like the TPAs who are kind of negotiating these contracts with the providers, it's not really in their interest to get lower reimbursement rates a lot of the time. And then the employers who are the fiduciaries here more clearly, they have such limited power in negotiating with the TPAs to have real influence over that. And then in the middle, you have these brokers and consultants who are just making lots of money and encouraging the plans to do, the employers to do whatever the TPAs want. And so it's just such a broken system on the payer side that I think it just complicates the analysis.
Yeah, and that was one of the things I struggled also when doing the game theory piece of it is, imagine, so assume you move away from simple form games and you have kind of the tree branching off. And you have all of the different players here, and then you have kind of signals they take from each other and how their goals are conflicting and how they respond to each other. I don't know. So, it's almost like the question, which I'll continue the discussion after, because I sense my orange light is going to come on soon, that, the question is, does it get us to simplify things so much for the paper? Is it helpful? What can we learn from oversimplifying things so much? And then, if I had more words, how can you then bring in the discussion, how that's only a piece of the game, and it's only part of it, but I appreciate that.
So we pair a few questions together. Erin, I definitely saw you had a question. You go first, then Chris, or Wendy first, and then we'll see if we have time for Chris. Go ahead.
So thank you. Couple of comments and a question. So one is the question goes to whether or not the Consolidated Appropriations Act of 2021, which creates more transparency and fiduciary responsibilities to the plan sponsor employers. So to me, right now, fiduciary law is being used in a way to force transparency so that plan sponsors can actually get information on prices from consultants and brokers that they never got before. So there's a worry to me that and then this goes to the provider fiduciary side as well, that maybe acknowledging the limitations of fiduciary law is useful, but maybe not throw the baby out with the bathwater. It's like a both and. I think Jill's point was getting to this of is there still some symbolic, ethical, normative work that these laws are doing, or real work, whether it comes to forcing price transparency from consultants and brokers to plan sponsors, and it creates remedies. I think that Barry's paper also does that. That yes, it's under-enforced, but do we need to sort of take it out of the toolbox? And I think that comes from my work with Mark. Now we're dealing with private equity, and we realize that there's a rampant corporate for-profit motive that is so much more unleashed when you actually put a private equity or a corporate investor at the steering wheel that we didn't see with like traditional providers. That they weren't profit maximizing to the fullest degree. And I don't know how much of that's professional ethics, and I don't know how much of that is fiduciary law, and how much of that are things like old school stuff that it's like, wow, we actually still need that stuff, because when you actually substitute the person at the steering wheel as a private equity investor, it's way worse. And so there's a worry to me about like, acknowledging the limits is fine, but then to say, let's get rid of it altogether is like, we may need those tools in the future. It's getting worse, not better.
So on the answer, Wendy, you go ahead first, the question.
I'll jump in. I know we're just really at the end here, so this is thoughts for later that you don't have to address now, but I think some of the themes that are coming up in these questions are, are you really doubling down on kind of the commodification of medicine and, focusing on incentives in that way? Does that move us too far away from trying to invoke more intrinsic motivation and altruism and this like model of what providers used to be? So, Mark has great work on consumerism in medicine, and if that's like the direction that we want to move things in. So I'll leave you to think about that.
Let's err on the side of input, so Chris, why don't you get your question in?
I wondered if Stark and anti-kickback statute and sorts of laws you have in mind, and if it'd be helpful for the chapter to at least waive it, the sorts of laws you have in mind, and if so, whether a very concrete recommendation would be to expand those existing laws to private health insurance plans rather than just federal.
They were, at least as a starting point. Oh, am I?
No, you're good. You've got 54 seconds to do
Okay,
whatever you
54
want.
seconds. They were at least as far as a starting point, and that was one of the questions I had before I went over my 5 minutes was, do I need to spend a little time, going through and doing that with where I can find words, I will do my best. I think one of the last things that I'll end on before I go to Red is, my question is, given the behavior a lot of people are talking about and writing about by private equity firms, if you take, that kind of really bad actor who's doing things that are antithetical to our goals for health, does sticking a fiduciary label and giving them fiduciary duties, does that mean they will engage in the system in a different way? Or does that mean that they will find some way to circumvent, make sure it's not enforced, or, so my concern has always been that it doesn't pull the weight, but I appreciate it.
Big round of applause for Lauren.
All right, to round things out, we're going to have a full-throated manifesto from William Sage in a paper, or to-be paper, public funds, public functions, private actors, the cognitive dissonance in U.S. health law.
Thank you, David. It's a pleasure to be here. I'm a latecomer to the project. My cheat sheet is electronic here because I didn't have a printer for printing out my outline. I was invited to join this project somewhat late, which is why I don't have a chapter, to do some of the sort of tying together. So I think of this as very much a back and forth. I enjoyed reading all your drafts. I learned a lot from them. I will learn more. Hopefully, as I say provocative things for the next few minutes, and then we talk about those provocative things, something will connect for many of you that might influence what you have in your chapter. This was a privilege to accept the invitation. It also was kind of funny because about 2/3 of my academic career connects to themes of this book. And that worries me to a degree because, if I'm wrong, it's a good thing. So make sure you point out if I'm wrong. I tend to do a little less in the innovation and bioscience space than I do in the professionalism, delivery, and national health policy space. So you may see a little bit of that. The way I was thinking about private law and health is that yes, there are opportunities that come with it. There are also pitfalls to be avoided. The opportunities, I think, are opportunities of necessity. They're not opportunities of choice. We have the system we have, and that creates a lot of room for private law. In fact, it creates possibly too little room for public law, but I think of this as not the system that we would ever design, but the system, in essence, we have to live with and try to improve. I'm going to illustrate this with a very recent quick story. Last Saturday, I found myself in the emergency department of a small Eastern Long Island hospital with a 98-year-old patient who had a bad fall at home and had craniofacial injuries. We had the best medical care I could ever imagine, but most of the medical care was provided by a 50-year-old woman physician assistant who was, I would say, born in Belgium, raised in the south of France, had an undergraduate degree in philology from a German university, an MBA, a career as a journalist, a master's degree in psychology, and then training as a physician assistant, and spoke French to the patient and family the whole time because it was more fun for both of them to do that. We had a lot of conversation, including about my background, and I said something about, I do most of my work in health policy, and she said, "What is health policy?" This is the experience I've had teaching health law and policy, particularly to European students over the years, and I'm sure some of you have had a similar experience. It's not intuitive to them that there is such thing as health policy. It is intuitive to us because we live with the reconstruction of health policy all the time from institutions and financial flows that on their own simply don't make sense. So when I teach about the US healthcare system, I basically describe it as a giant money laundering operation. We take trillions of dollars in public funds, most of which is by consensus intended for public functions, and for various reasons we filter it through private organizations. And it's also interesting, I have one schematic I sometimes use that sort of shows the publicly financed and privately financed health coverage systems in this country. And once you get past the sources of the funds, everything else funnels into a common pathway. The same organizations, the same self-regulatory bodies, everybody controls both sides of this. It is a big, old, mushed system. And to me, the lessons of this sort of unfortunate private cast of public functions and public funding, more than half of the system being ultimately publicly funded, is best illustrated by the lessons from the COVID pandemic, which I don't even need notes to kind of say. Number one, financing healthcare services through elective procedures paid by private insurance organizations is idiotic. And we saw the effect of that, where hospitals shut down, physician groups shut down, until the government finally did something it's unaccustomed to doing, except in major economic downturns and something like a global pandemic, came up with cash. Our system was on the verge of imploding because the things that finance all of this public function were suddenly, restricted because we give them this private and highly selective private gloss. Associated with that, we have a very limited publicly employed, explicitly public workforce in health in this country. All of those community functions we offload to private organizations where most of the funding ultimately comes through private insurance payer organizations. We paid a price for both of these. In the pandemic, it was absolutely essential that all of these skilled people would come together and deliver services and do what was needed to protect the public's health and individual care, and instead, large numbers of them were being furloughed. And that was just crazy. What else did we learn from the pandemic? We learned that equity matters in a central core way in a system that's not really built around equity. And then we learned that most of the accreted health law that exists out there, much of which governs private transactions, kind of got in the way. And we had to brush clear a whole bunch of it, and now we're worried about going back. And to me, this very clearly illustrates the dangers of the nominally private but publicly needed system that we've created. To give a lot of room for discussion, let me just sort of outline kind of how we created this pretense of a private healthcare market. And by the way, when I talk about health policy, I usually ask the audience how many zeros are in a trillion. The correct answer being 12. I said this at Yale Law School in an MLP conference back in April, and there was silence, and then some wag on my panel said, we went to law school so we wouldn't have to do math. And if you don't understand there's 12 zeros in a trillion, you don't understand how much potential for mischief there is in this privatized U.S. health policy. And I say this in all seriousness, that I think U.S. health policy would be significantly different, and so would a few other areas of American public investment, if in the English language the words for million, billion, and trillion did not rhyme. I'm not kidding about that. I really have thought about that a lot over the years. So how did we get in this? Well, we got in it, first of all, because we empowered and relied on the American medical profession to oversee and, in fact, design our healthcare system. In other words, we took this dyadic relationship between a physician and a patient. We tried to insulate it from outside influence as much as we could, and then we lavishly subsidized it. And then we imagined we would extrapolate that to the population level and call it a healthcare system, which it isn't, and it doesn't have a coherent policy behind it. But that's, to me, the basic premise of what we've done. And we could talk about sort of what's happened in the sort of the service space to that. You know, the physician's pen still being in control of roughly 70% of overall U.S. health expenditures, but that could be for our conversation. The second piece is sort of the weird way that we constitute legal federalism, and the way we've typically done that, and this is sort of functionally more than constitutionally, is that state actors have defined the substantive rules of healthcare, and the federal government, as it often is, has been a bank and has funded the system that the state rules created. And once those state rules were created with great deference to the self-regulatory control of the medical profession, we had a system where we kept pouring money in and found it very hard to see what we were getting. Third thing that's really important, and I, as many of you know, I started my health policy work in the Clinton White House in 1993, having done the MD-JD before that, is kind of the role of post-1970s federal and, to a degree, state fiscal policy and fiscal politics. And you see the exceptions of this when there is a major economic downturn. So we got the High-Tech Act and then the ACA. Without the High-Tech Act, I don't know if we would have been able to fund the ACA. Saw this again in recent years, with the pandemic and pandemic-related funding, which was seen as stimulus, but was actually not stimulus. It was support for a number of functions that actually needed to be operationally supported. But the bottom line of U.S. fiscal rules is, first of all, we're very uncomfortable with anything that we call a tax, anything that we call an increase in the size of government, and if you want to change anything that hits those sort of public landmarks, explicit public landmarks, it has to pass Congress twice. And you know how hard it is to pass Congress once. But it has to pass once on its merits and has to pass another time on its fiscal impact. And if you can't do that, then you throw everything into either off-budget mechanisms or mechanisms that have interest group support that you can somehow finesse the fiscal rules with respect to. And sort of the last factor after, professional control, this sort of division of legal governance and federalism and the fiscal policy side is really the role of interest groups. And again, in a $4.4 trillion system, there's lots of room to hide $1 billion here, $1 billion there, $10 billion here, $10 billion there. And what we've ended up with, Larry Jacobs from Minnesota said this decades ago, and I still assign the article, is the politics of what he called America's supply state, a state that prioritizes the supply of new stuff over the universality of access to existing stuff. In other words, a core characteristic of what's been our public system. So let me stop there, and we have at least about 9 minutes for chatting.
Fantastic. Let's get some questions. Craig, go ahead.
So this is fascinating. I loved it. I guess the question I have is, does this sort of play to the hands of the other side, or what I would consider the other side, what I think you would consider to be the other side? But they say, oh great, take public money out of healthcare altogether. right? And there won't be money laundering at all, because, you know, as you provocatively put it, that I'm not necessarily in disagreement even with the provocative framing, because, you know, then you just have private entities doing private things with healthcare, people paying out of pocket or using their employees, et cetera, et cetera. So does the reliance on, your argument's reliance on the fact that there's public money being used by private entities, if you take public money out, does your argument still work?
I think functionally, Craig, there's no way to take public money out. I mean, what I would like to do is take a quarter to a third out of medical care expenditure, put about half of that ballpark into other sorts of public benefit investments, and give half back to private people to spend as they see fit. That's actually what I would like to see happen. I think what we end up doing is we have to sort of manage the public money that's there. None of the sort of efforts to take public money out of healthcare have ever gotten us very far because the entire system relies on them. I mean, one thing I think is a policy lesson for me over the years is everybody in the system does what's easiest to do, and even though they might like to do what's harder, they seldom succeed in doing it. For example, in what we ostensibly regard as a healthcare marketplace, I think there's hardly an actual buyer in the market. So, you know, to me, insurance companies, with the occasional exceptions that prove the rule, they're like the house in a casino. They take a cut of the action. At the end of the day, they want more revenue flowing through the system, not less. So where's the impetus to take money out of the system?
So this panel, quick follow-up, which is, so then does your critique apply to contractors in general for the government?
That's more of an offline conversation. You know, it gets to the details. But I would have different issues on PBMs versus TPAs. And in fact, my read on Rutledge, which I, for whatever reason, predicted the outcome of, was that people, I think, correctly regarded PBMs as suppliers, sellers, not buyers. And if you think of PBMs as sellers, not buyers, it's easier to reach that result.
Carmela, you had a question next.
Yeah, so, I mean, first of all, I think that you could write a book entirely just on this. So, good luck getting 5,000 words in everyone. My question is, so it seems like you're saying, okay, we're not going to go to an entirely public system, so we can't get rid of money laundering in that direction. As we've just covered, you said we can't take public money entirely out of the system. So you're saying, okay, it would be great if we dialed down the amount of public money, and I'm wondering if you think that's because it's a sweet spot or simply because it limits risk exposure for money laundering and malfeasance.
But again, money laundering is a feature, not a bug. This is the system we've created because it's a system we're comfortable with. It's a crappy system, and the pandemic should have proved it, but we're not good at learning lessons from many things, including the pandemic. There are a few prescriptions that I could attach. It's where I sort of get practical in this stuff. So, you know, number one, for one of the top ones for me, is reducing payment differentials between different sources of coverage. I mean, if what Medicare paid and private insurers paid and Medicaid paid, sort of the differences were somewhat narrowed, I think the organizations that are feeding at those troughs would make somewhat more rational decisions. I also think that if payment structures were at least open to going beyond the traditional hegemonic physician control, things could improve. For example, I like to go particularly in Texas and say, okay, here's my really radical idea, and I have not advanced practice nursing, but core nursing in mind. I say, okay, here's a really radical idea. When a health professional does something that measurably benefits a patient, that individual should be fairly paid for doing it.
Jill.
Radical. Is the oncoming demographic disaster that we're facing in terms of the demand for health care as our country ages an opportunity or a challenge to this?
I mean, as the old saying went, I forget which of, I guess, was it FDR's advisors or Truman's, if something can't continue, it won't. And we keep sort of struggling with when will we fall off the fiscal cliff and when are we going to deal with the demographic change. And I think, you know, my sense is kind of never. And then you kind of look on the demographic side to immigration and other sorts of factors as kind of drawing that out further. Obviously, if you know, we get into the macroeconomics of interest rates and the global role of the dollar, then things could look much dicier much more quickly. But I think at the end of the day, the demographics is going to challenge us, I hope, more on the professional categorizations, but I have a feeling it's not going to challenge us enough on the core funding and the sacrifices we make to fund medical care to the exclusion of other things.
Great, let's pair the last two questions for Becky and Elizabeth. Go ahead, Becky.
Yeah, so I think you've got more than enough material here, but just a suggestion would be thinking about maybe the Moderna vaccine as another example, where there's been a lot of discomfort with labeling that as the NIH Moderna vaccine. Everyone refers to it as the Moderna vaccine, right? So there would be another example of strongly publicly funded resource, but it's referred to as the invention of purely a private company.
Well, I think that
Hold your answer, yeah, sure. Got the question first.
So related, I'm wondering if you see any potential or openings for using this kind of rush to add transparency as an incremental reform to being able to try to force some transparency about the level of public funding for various bigger aspects.
So two responses. One sort of to the first question, a really interesting area of this is to what extent the sort of post-Tea Party politics and then the post-Trump politics have accentuated the distrust of public investment. That's, all of these things I talk about predate this era. Very little of it is directly a result, and yet the suspicions accentuate the problems at this point and maybe change the solution space a little in ways that some of your chapters will address. Liz, thanks for mentioning information policy. Here's one of the areas where I think there's extraordinary potential for advances, but pretty much you should leave the existing medical care system out of them. When I need to be provocative but accurate about healthcare information, in other words, what the healthcare system has created, I simply say the following. In the U.S. healthcare system, we collect the information we need to collect in order to get paid.
Great, time for one more question, if anybody has one. Okay, Bill, you have the last word. Anything else you want to say?
Nope, thank you.
Thank you very much. Big round of applause.